Justice Department just has named a former FBI Director Robert Mueller to be special counsel for the Russia probe. This follows, of course, the revelation Tuesday that fired FBI Director James Comey wrote in a memo that Trump had asked him to end an investigation into former National Security Advisor Michael Flynn. I want to bring in our legal panel, and as is the norm nowadays, breaking news, we pivot as the show goes on here. We're going to talk about what this means, what Mueller can and can't do. Jim Kasouris, criminal defense attorney in Manhattan, sitting on the board of directors of the New York City Criminal Bar Association, frequently lecturing at New York Law School and the bar associations in Queens and New York City. Mayo Bartlett, attorney at the law offices of Mayo Bartlett PLC, is also former chief of the Bias Crimes Unit at the Westchester County DA's office. And Mark Furnish, adjunct professor at the Elizabeth House School of Law at Pace University, and he's argued before the U.S. Supreme Court. All right, Mayo, I think this is a distinction with a difference. When we say a title, people have been looking for an independent prosecutor, okay? Mr. Mueller is actually a special counsel, okay, which is different than an independent counsel, and it's different than an independent prosecutor. Now, maybe it's not too much of a difference, but reportedly, he's got to report through the Justice Department, and theoretically, Jeff Sessions, who has been nothing but an apologist for the president, can say, even though he's supposedly recused himself, he or his office can say, don't go in this direction, stand down, and whatever else. How real is what I just said versus how practical is it that Robert Mueller isn't going to let anybody tell him where he can and can't go in an investigation? And as we've seen, the leaks will come out within a matter of minutes.
Well, the question is, I don't think that a lot of people believe that Comey was going to do what they wanted him to do. That's the prevailing wisdom, is that that's why he's no longer director of the FBI. You need an independent prosecutor that has his or her own budget, resources, that are totally independent of Department of Justice, especially in a situation where the Department of Justice is led by a person who had to recuse himself. So if Mr. Sessions is involved in this case, it just at a bare minimum gives the appearance of impropriety, and one of the key reasons of having an independent prosecutor is so that people will have faith in the system. They'll believe that there's a chance that it'll work.
Does this special counsel, Robert Mueller, however, carry different weight because he ran the FBI? He's not going to be bullied by anybody. One would think here he certainly wouldn't put his reputation on the line, and he hasn't in the past. Is it different because it's him?
Well, he carries a lot more gravitas, but you're right, it is a distinction with a difference, and Jimmy, as a sharp cross-examiner, knows this. There's no such thing as an FBI agent who's not special. Every FBI agent is called a special agent. So you're right, special counsel is an adjunct of DOJ and will report up through the chain of command. A lot of times it happens when one U.S. Attorney's Office has a conflict, so they bring in a prosecutor from another district and they call him, guess what, a special counsel. But this guy is a guy with a difference. I do expect that Sessions will be true to his word and he'll stand down on this. Rosenstein, as we've talked about, this memo notwithstanding, is a guy of unimpeachable integrity. And
do you believe that Rosenstein did this without the blessing of the White House?
No. I think that
he still has his job.
He has a job. I think he was asked to write the memo, and I think that memo reflects his honest opinions.
And you think there was an inevitability? It's a guess here from the White House that they had to do this route before the Senate forced their hand.
Well, I don't.
It certainly seems that way from at least what I'm learning granularly on the floor.
You mean the Mueller thing?
Yeah, that they had to appoint somebody as an investigator outside of this.
Mueller, notwithstanding his impeccable reputation, for the reasons that you've said, that he's still an adjunct of DOJ, I don't think that's going to satisfy the critics.
Jimmy, at the end of the day, it seems with all the connections, proven or otherwise right now, the charge, at least, that people are saying is this smells, this feels like obstruction of justice. And there's two parts to this. There's the legal, which we'll talk about, and then there's the political, because in the end of the day, the House and the Senate have to go along to get along, and they have to make their own political calculations if they're willing to go there. Talk about the standard from obstruction of justice here, and also how this is going to come down to, at the end of the day, to he said, he said.
That's exactly what it's going to come down to. Look, obstruction of justice is impeding an ongoing investigation. I asked Mark about this before. That is in contemplation of a proceeding. It doesn't smell like it. If it happened, it is. for the
And don't his
president.
own words, sorry to interrupt you.
Sure.
But didn't the president's own words, whether it be with the Lester Holt interview, the tweets at 5 a.m. in the morning and otherwise saying, yeah, I wanted to fire him. And he talked about Russia as being the primary cause at the end of the day, didn't like where he was going with this, etc. And now apparently we have the details and the memos and everything else to speak to it. My point is, to the layman it feels like it, but you also have to prove motive, don't you?
You have to prove a corrupt intent, and it's very simple. Take just this statement to Director Comey, asking him to drop the investigation on Michael Flynn, on Flynn. Now, then you take all that peripheral stuff, where he wanted to fire him because of the way he treated Clinton, because he wanted to fire him because of the way he was dealing with Russia. You have all of that other stuff in there that basically tells you he didn't like the way it was going with Director Comey. He asked him for loyalty, and instead he got honesty, and then supposedly he asked him to drop an investigation, and he didn't. So that's on the periphery.
Yeah, but
on the obstruction, it's very simple.
It's not
Did he ask him that he obstructed investigation?
That's the firing isn't going to be the obstruction, because there's no dispute that he's entitled to fire for any reason or no reason. Comey said as much in his parting letter. The crux of this is the words that he used asking him to drop the investigation.
But a legal act can be an obstruction if it's done with a corrupt purpose.
But you
Well,
also
the
have to
corrupt,
look-
the
the
corrupt
fact that
intent,
he's-
we talked about this
Right.
last week, is the key to this. So the memo itself is likely not definitively inadmissible hearsay. So that's not coming in. There are some
But just
theories.
make one distinction.
acceptable.
I defer to you guys legally, but there's going to be hearings. It looks as early as next week. If they subpoena, and they're going to, and Comey goes before it, and they say, read the memos. Again, so I'm saying this is not a criminal proceeding where Donald Trump's going to be let off in handcuffs. At the end of the day,
Well, there
politically,
could be a criminal proceeding.
there
He
could
could
be.
get indicted.
But more
But you could
practically,
also-
politically, he's going to read the memos, Mayo, and then people are going to have to make a decision. Do I trust the president, who by all accounts said, hey, Pence, hey, Sessions, get out of the room. I just want me and Comey here. And then he says, make it go away, talking about Flynn, and then another conversation, pledge me your loyalty.
Well, look, Rich, that's the difference. Make it go away is a much more damning statement.
That's
But Mark, to the
Asking
same
somebody
point,
to
though,
go
you have
away.
you have to stop, and you
it-
do also
it's
have to
much
understand that
gray
you're
area.
correct. The president has the ability to fire. Most people that are working are an employee at will. So you can be fired for no reason or for any reason. However, when the employer states a reason, that's where they get themselves in trouble. And in this situation, if the president states a reason, he can undo that privilege of being able to fire the
Well, I
director.
think
Really,
it goes,
guys,
I think
have
it goes
so little time.
beyond
I have
that.
so much more I want to ask you. Just really quickly in a minute, the tapes. We don't know if they exist. We don't know if they don't. Of course, the president introduced this one. If the president, everyone always said, if Nixon had to do it over again, he should have gone to the White House lawn and burned the tapes right there, okay? But at the end of the day,
There weren't
because
the
of what he
statutes then
said,
that there
if
are
he
now.
destroyed the tapes right now,
No, that would be bad.
Well,
bad,
absolutely.
bad.
Then
optically bad or criminally bad?
Both.
Criminally bad.
Both.
Criminally. Look, we'll take this up again at the break if we can, because I'd like to answer what Mayo said. I actually think it goes farther than what Mayo said about the firing. The very fact of the firing is circumstantial evidence of the corrupt intent, because the words themselves that he reputedly used are in a gray area. The proof of the fact that he went back a month later and fired him casts those words potentially in a more
I'm gonna hit a break.
nefarious
When I
light.
come back, I'm going to have you guys be the ones posing the questions. What questions would you want answered, from whom, and what, in effect, would be smoking guns? Here, we'll be right back after this with our panel of attorneys.